5 of ECCB Connects is almost at a close. Thanks for staying connected with us, and be sure to join us in January 2018 when we bring you new and informative programs about who we are, what we do, and how we serve you.
Hi, and welcome to the end of Season 5 of ECCB Connects. As we wrap up this season, Delano Bart, attorney at law, explains the importance of preparing a will.
So what is estate planning? Well, everything that you have, every asset that you have is in fact part of your estate. So your bank accounts, your home, your car, and smaller assets, anything that you can think of, even debts which are owing to you, are in fact your assets. And so they, in a sense, collectively is referred to as your estate. And in a sense, when you look at it from the standpoint of the question of planning, that estate is determined to some extent what one calls in the law your net worth. Now, it's fashionable to speak in terms of net worth in relation to the very rich. But every one of us here have a net worth. The only thing that influences it is that you have to, as it were, seek to, in order to make sense, you have to seek to ensure that your assets are in excess of your liabilities. Because at the end of the day, if your assets are less than your liabilities, it means you really have a negative net worth. And you can't make good use of that in terms of a future planning of your estate. In setting up your, looking at your estate planning, you look at attitudes of your families, their needs, their dispositions, and their own abilities at times, because they're not all going to be equal, so you've got to find a way of assisting them as you go along. And so, in doing that, you take into account what will protect this, this group or this kid or the grandchildren as compared to another one. In that case, there are in fact two particular instruments which are important. One is called a trust, and the other is the will. Now, in terms of the trust, I'm not going to go into great detail about it, but it's a very important instrument because at the end of the day, while you are alive, you are able, in a sense, to look at things as you go along. So, for instance, you can put assets into the trust, you can see how it's being used, you can make an assessment of your kids, your loved ones as you go along, and determine how you're going to set that trust up and how you're going to act or hope that the trustees deal with the assets in relation to those children. And a trust exists when a person holds or has vested in him assets which aren't his, but he holds it on behalf of other people for the benefit of other people or for a purpose. And why for a beneficial purpose? Not necessarily for a person, but for something like a charity or so on. And in looking at your estate, some of the things you have to consider is exactly what do you want done with your money? What's your legacy? Do you want to give some to the church? Do you want to give some to look after animals, medical research, or whatever? And in that situation, you can, in the trust, make provisions for those institutions to be assisted. Any person can create a trust, and they must do so basically for a lawful purpose. And you do that once you have vested the assets in the trustee, and the trustee accepts that on behalf of the individuals that you are considering looking after. Now, there are a few types of trust, which I'm going to just simply identify them, but and not necessarily go into any great depth. The first is the charitable trust, which I've just hinted at, which gives you the opportunity to do charitable, to do good with the assets. So you can have, as it were, an asset, your estate, and you decide half is for my family, and you do a trust in relation to them insofar as that's concerned, and then you may want to give the church or some others the other half. And then you have the Spendthrift Trust, and that trust now is the one that you try to use to protect your kid or your grandchildren, because inside of that trust you can actually put restrictions on how the assets can proceed and can be used. In the documents in relation to the trust, the obligation to ensure that those kids or individuals behave in a certain way, otherwise they can lose their rights to the access to the benefits of the trust. The trust, of course, has to be valid, and it must have some form of beneficiary, otherwise it's not going to be valid. Then you also have the appointment of the trustees, who have certain specific obligations, and you also have the need for a beneficiary or beneficiaries who have to be identified and be clear who the beneficiaries are, or alternatively, that they belong to a specific class. You identify the class in such a way that you don't make a mistake. Because one of the difficulties, of course, you can actually set up this trust, and if it fails, you're back to square one. And one of the other difficulties about your assets, if you don't get it right, and you don't have any identifiable beneficiaries or relatives, etc., the state is going to end up with your property. And I'm sure that you'd rather be able at least to give it to the church in many cases, rather than have the church and the state have it or take it over. But there's one thing that, to be fair, that once the state takes it over, if it does do so, it's under the principle of bona vacante. You can make representations to them, and they may be able, or your family can make representations to them in relation to that. Now, the other means that you can address the question of how things are handled for you beyond the grave is the use of a will. Now, the law that governs the will, to a large extent, depends upon where you're domiciled. If you're in St. Kitts and you're from St. Kitts, there's a fair chance that the law of your domicile is St. Kitts unless you have changed it. But if you're from Dominica, St. Lucia, or one of the other islands, the mere fact that you're living here doesn't automatically mean that the law of St. Kitts governs your will. It may be that you have such strong ties at home, and also the assets may be back at home, and so those things could be governed by the laws of St. Lucia or where you're from. So that you have to get your own individual advice in relation to that. The assets, again, generally would be freehold property, leaseholds, bank accounts, debts, and so on, as I've said. The shares in companies, those types of, even properties which are to be sold, the proceeds, etc., those things can also, you can make wills in terms of how they are to be governed, because they're all part of your estate. One of the things, though, you have to bear in mind about a will is that if you do have an asset which is jointly owned with another person, it depends upon the nature of that joint ownership. There are two ways that you can jointly own a property with another person. One is called a joint tenancy, and the other is called a tenant in common. Now, if you own the house as a joint tenant as opposed to as a tenant in common, that property, even if you put it in the will, is not in the will. Because when you die, the surviving person gets that asset passes to them. So even if you have written it into the will, unless, and this is very important, unless you have demonstrated in some way that you have severed or divided the tenancy. On the other hand, if you have got one which you owned as a tenant in common, it means that from the word go, half is already yours, the other half belongs to the other person. But if you put the property in, it's only your half that you're going to be able to make a judgment on as to how it can be disposed. The other person's half stays with them. Of course, in that situation, you probably have to end up selling or the property being sold so that you can access that bit of it. But there are some people who cannot benefit under a will. For instance, beneficiaries who, and this is so obvious that it's ridiculous to say it, but sometimes you have to think about it because it has some consequences. Beneficiaries who are identified in the will, but who have died before the testator. Now, that you laugh, but let me tell you why it can be important that you understand it. Because if your name is in the will, but you have died before the testators, your kids may think that they're entitled to the asset. They're not. And so if you die before the beneficiary, before the testator, your kids are out. Another person who cannot benefit under a will is anyone who is a witness to the will. The law has a public policy on that, and that has to do with an area of law to some extent which is called the use of undue influence. There is almost a presumption that if my name is in the will and I'm there signing and witnessing it, I was doing it to make sure that he didn't change the will in my absence. And so there's basically, well, it's not just a presumption, it's virtually a matter of law that you're not entitled to benefit if you are a witness to a will. And another obvious one, if after you have heard that the will was written and you're in it and you decide that it's time to bump him off so that you could get the assets on the will as a matter of public policy, those who have committed murder or manslaughter of the testator cannot benefit under the will. Now, apart from the obvious things like the beneficiaries, there are a few other things that you can put into the will which may or may not be important to some of you. For instance, you can actually have your funeral arrangements put in the will. You can also have a description as to how the body should be disposed of, whether by burial, by sea, burial at sea, burial at Springfield, the cremation, or whether you want to gift the body for research. But all of these things must be done in accordance with the law. So you can't just decide, oh, well, I want the body burned, but let's do it up at, in the middle of the park if the law doesn't allow it. This is also fairly important, is that in relation to a child under 18, if you're ill and you know you're going to die, this child is young, you're concerned about it, the law here, it actually speaks only of the father, but I imagine at some point it could be changed to include that of the mother. You can actually make arrangements in relation to the custody and education of your child, identifying someone to be in charge of the child until they're 18. And that they will have, the person who takes on that responsibility will have the same authority as if they were appointed as a guardian under any statute of the country. The form of a will, we know it has to be in writing, it has to be executed in accordance with the law, and it has to be clear, this is also very important, it has to be clear that it is intended to operate after your death. If there is any confusion about whether you're intending that it operates after your death or not, the fact is it will not be a valid will. So you have to ensure that that is explicit. The signature, very important, it has to be signed, except of course for soldiers and sailors, etc. in war. There are special rules for them. But in terms of the ordinary will, it has to be signed. Now, a will, very much unlike the trust, you can revoke it clearly before you die. And that is a very interesting point, because if you're looking at what someone is doing and you're not happy, you can revoke the will and write a completely new one. You can do that in several ways. You can execute another will. You can also tear it up or burn it, destroy it in whatever form. And if you don't like the wife you're connected to, you get divorced and get remarried, and then by that remarriage, that old will is revoked. And so those are the ways that you can, so some of the ways you can bring it to an end. The trust was really intended, as I hinted, to protect the generations of your family. Because what they discovered, and the data tended to suggest, was that they called it 2 short sleeves and a shovel. And what it meant was that one generation works hard, builds the money, the second generation tends to protect it, but the third generation spends it. And so you then go back to the shovel and the hard work. And so that's the reason why you have the trust. There's some advantages and disadvantages connected with the trust. First of all is that unlike the will, you don't have to wait until probate takes place for the beneficiaries to have access to the asset. It also gives you a chance to see how things are working. You can preserve your estate and protect it from the impact of inheritance taxes. Some disadvantage is that it can be expensive to have. The property is no longer yours, and as I say, it's difficult to revoke. And also a very interesting point is that the family, in most part, already have an idea what's for them and probably have it, so they're not going to care too much about you afterwards as to how they treat you. But in terms of the will, there's some advantages and disadvantages too. It's generally cheaper. You can end up paying debt duties in some of the jurisdictions, as I've pointed out. And you can change your mind and you can revoke it. And the family really doesn't know where they stand. So you might have a little bit more protection in terms of the way that they treat you until after the will is read. So it gives you a tact, you can keep your cards to your chest. And finally, just a cautionary note as I end, you may want to consider this, especially the young ones. One of the things that we love to do is to build our dream homes, the huge, fancy swimming pools and etc. And nothing's wrong with that. And quite often we do it because the kids are coming, the kids are there, and you believe they're going to come back home. And then you send them off to university, and as someone said, you invest in them, but they don't come back. And now you have a huge asset here, and you die. And the problem is, you may not be able to rent it because it's too huge. Can't sell it because it was your design. Not many other people want your design. And so the kids now have an asset which simply stays there. You look around here and you see it. They deteriorate and you can't access it. And if they're going to do anything about it, it's going to cost them money to maintain it. So it ends up deteriorating. So my simple advice to you is this, that in planning, bear in mind that they may not come back home. Build in a way that you can, for instance, divide into apartments so that you can sell those off separately. Or choose a design that you know that is functional so other people would want to buy it or to use it after you've gone. That way, you might be able to preserve the asset and at least pass on a legacy to your kids. Thank you very much.
To view any episode of ECCB Connects, anytime, any place, at your convenience, check out our YouTube channel, ECCB Connects.
We've come to the end of Season 5 of ECCB Connects. Thanks for staying with us throughout the season. As usual, we'll be going on a short break, but we'll be back in January with brand new episodes. In the meantime, stay connected with us on our Facebook page. See you in the new year.